When the owners of Cleburne Living Center attempted to build a group home to help the mentally disabled, little did they know their project would leave them embroiled in a landmark legal case about the meaning of the Equal Protection Clause. Zoning regulations in Cleburne, Texas required a special use permit for hospitals serving the, quote, insane or feeble-minded, unquote. Cleburne Living Center applied for the special use zoning permit, but after a public hearing, the city council denied the application. The center responded by filing suit against the city, alleging that the zoning ordinance was invalid because it discriminated against the mentally disabled in violation of the Equal Protection Clause. The district court disagreed, holding that mental disability was neither a suspect classification nor a quasi-suspect classification. A suspect classification refers to a class of individuals that have experienced a history of purposefully unequal treatment. When a law makes a suspect classification, such as by race, the law is subject to strict judicial scrutiny. Quasi-suspect classifications, such as gender, are subject to intermediate judicial scrutiny. The third and most deferential level of scrutiny is rational basis review. This is the default standard for social and economic laws with classifications that are neither suspect nor quasi-suspect. On appeal, the Fifth Circuit reversed the district court. The Fifth Circuit determined that mental disability was a quasi-suspect classification. Therefore, the appeals court applied intermediate scrutiny to hold that the ordinance was facially invalid under the Equal Protection Clause. The issue before the United States Supreme Court was whether the mentally disabled are part of a quasi-suspect class and whether the city of Cleburne's ordinance violated the Equal Protection Clause under the applicable level of scrutiny. The court held that the mentally disabled are not a quasi-suspect class, and any laws affecting their rights are subject to rational basis review. In a 6-3 decision authored by Justice White, the court reasoned that the deferential rational basis standard should apply because legislators, rather than the judiciary, are better suited for determining how the mentally disabled should be treated under the law. The court found that federal lawmakers had already enacted significant legislation for the protection of the mentally disabled. This demonstrated that the mentally disabled weren't politically powerless and therefore didn't constitute a quasi-suspect or suspect class. The court held, however, that the mentally disabled still enjoy constitutional protection from invidious discrimination under rational basis review. This deferential level of judicial scrutiny requires any law that treats the mentally disabled differently from others to be rationally related to a legitimate governmental purpose. Using rational basis review, the court found that Cleburne's ordinance requiring a special use permit for the mentally disabled rested on an irrational prejudice. The court came to this conclusion because Cleburne didn't require a special use permit for other group living buildings, including apartments, boarding houses, fraternity or sorority houses, dormitories, hospitals, and nursing homes for convalescents or the elderly. This difference in treatment, according to the court, was not rationally related to a legitimate city interest, and thus didn't survive rational basis review. Unlike the Court of Appeals, which facially invalidated the ordinance, the Supreme Court invalidated the statute only as applied to the group home in this case. Therefore, the Supreme Court partially affirmed the holding of the Court of Appeals. Justice Stevens, in a concurring opinion, criticized the three-tiered scrutiny analysis under the Equal Protection Clause. Stevens argued that strict or intermediate scrutiny is unnecessary to properly decide cases that implicate the Equal Protection Clause. Rational basis review, Stevens contended, is adequate to determine all equal protection questions. Justice Marshall, concurring in the judgment in part and dissenting in part, argued that the majority erred in striking down the statute only as applied to the Living Center. Instead, Marshall contended that the statute was facially unconstitutional. According to Marshall, the ordinance should be subject to strict scrutiny instead of rational basis review because of the importance of the interests at stake and the history of discrimination against the mentally disabled. City of Cleburne shows that a classification doesn't necessarily need to be suspect or quasi-suspect to raise equal protection concerns. It remains one of the rare cases in Supreme Court history to find legislation unconstitutional under the rational basis test, which is typically understood to be a highly deferential standard.